The accused has been found responsible for aiding and abetting, as well as planning, some of the most heinous and brutal crimes recorded in human history. The trial chamber is of the view that the offences for which the accused has been convicted, acts of terrorism, murder, rape, sexual slavery, cruel treatment, recruitment of child soldiers, enslavement and pillage, are of the utmost gravity in terms of the scale and brutality of the offences, the suffering caused by them on victims and the families of victims, and the vulnerability and number of victims. In determining an appropriate sentence for the accused, the trial chamber has taken into account the tremendous suffering caused by the commission of the crimes for which the accused is convicted of planning and aiding and abetting, and the impact of these crimes on the victims, physically, emotionally, and psychologically. The trial chamber recalls the tremendous loss of life, innocent civilians burned to death in their homes or brutally killed by maiming and torture. The amputation of limbs was a hallmark of terror and cruelty visited upon innocent civilians. For those who survived these crimes, the long-term impact on their lives is devastating. Amputees without arms who now have to live on charity because they can no longer work. Young girls who have been publicly stigmatized and will never recover from the trauma of rape and sexual slavery to which they were subjected, in some cases resulting in pregnancy and additional stigma from the children born thereof. Child soldiers, boys and girls, who are suffering from public stigma highlighted by the identifying marks carved on their bodies and enduring the after effects of years of brutality, often irreparable alienation from their family and community, all as a consequence of the crimes for which Mr. Taylor stands convicted of aiding and abetting and planning. The defence aptly described, quote, "the pain of lost limbs, the agony of not only rape in its commonly understood sense, but also the rape of childhood, the rape of innocence, possibly the rape of hope," unquote. The trial chamber witnessed many survivors weeping as they testified a decade after the end of the conflict. Their suffering will be lifelong. In assessing the gravity of the crimes committed, the trial chamber recalls the evidence of several witnesses whose testimony highlights the brutality of the crimes committed, the suffering caused by these crimes on the victims, and their vulnerability. Witness TF1 064 was forced to carry a bag containing human heads to Tombadou. On the way, the rebels ordered her to laugh as she carried the bags dripping with blood. TF1 064 testified that when they arrived at Tombadou, the bag was emptied and she saw the heads of her children. Witness TF1 143 was 12 years old when he and 50 other boys and girls were captured by Revolutionary United Front rebels in September 1998 in Konkoba. The rebels turned him into a child soldier after carving the letters RUF on his chest. Having been told to amputate the hands of those who resisted him, this 12-year-old subsequently used a machete to amputate the hands of men who had refused to open the door of their shop. When ordered on a food-finding mission to rape an old woman they found at a farmhouse, the boy cried and refused, for which he was punished. The trial chamber recalls the testimony of TF1 358, who treated a young nursing mother whose eyes had been pulled out from their sockets after she was gang raped by 7 armed rebels. so that she would not be able to later identify them. The scale and brutality of the crimes committed in Sierra Leone, as demonstrated by these individual incidents, is also clearly demonstrated by the code names given by the perpetrators to the military campaigns in which the crimes were committed. Names such as Operation Spare No Soul and Operation No Living Thing, indicating the indiscriminate killing of anything that moved, speak for themselves as to the gravity of the crimes committed. The trial chamber notes that the effects of these crimes on the families of the victims, as well as the society as a whole, are devastating. A number of physically handicapped Sierra Leoneans have been left unable to do the simplest tasks we take for granted as a direct result of amputation. Many of the victims were productive members of society, breadwinners for their families, and are now reduced to beggars, unable to work as a result of the injuries inflicted on them. They are no longer productive members of society. Particularly reprehensible were the crimes committed against vulnerable groups. Girls and women were raped, subjected to sexual slavery, and in many cases unwanted pregnancy. Pregnant women were cut open to settle bets as to the sex of the unborn child. Child soldiers, both boys and girls, had their innocence stolen and were forced to commit murders, rapes and mutilations at a very young age, their lives permanently marred by these traumatic experiences. Elderly men and women, a particularly vulnerable group, were also affected by the crimes committed, their dignity violated by brutal attacks and cruel treatment. In assessing the role of Mr. Taylor, the trial chamber has considered the modes of liability under which he was convicted, as well as the nature and degree of his participation. The trial chamber recalls that Mr. Taylor's conviction for aiding and abetting the commission of crimes by the Armed Forces Revolutionary Council Revolutionary United Front is based on a number of interventions. In addition to supplying arms and ammunition and providing military personnel, Mr. Taylor provided various forms of sustained operational support, including communications and logistical support. In addition to this practical assistance, Mr. Taylor also provided encouragement and moral support through ongoing consultation and guidance. The cumulative impact of these various acts of aiding and abetting heightens the gravity of Mr. Taylor's criminal conduct in the view of the trial chamber. Moreover, the steady flow of arms and ammunition that he supplied extended the duration of the Sierra Leone conflict and the commission of crimes it entailed. Had the RUF, AFRC not had this support from Mr. Taylor, the conflict and the commission of crimes might have ended much earlier. With regard to Mr. Taylor's conviction for planning the commission of crimes in the attacks on Kono and McKenney and in the invasion of and retreat from Freetown between December 1998 and February 1999, the trial chamber notes the submission by the defence distinguishing the design of the overall operation from the planning of the actual crimes that were perpetrated. The trial chamber does not accept this distinction and recalls its finding that, having drawn up the plan with Bockary, Mr. Taylor followed its implementation closely via daily communications, either directly or through Benjamin Yeten. The prosecution argues that the length of time over which the crimes were committed, spanning up to 5 years, should be taken into account as an aggravating factor. The trial chamber has considered this issue in the context of its consideration of the gravity of the offence rather than as an aggravating factor. The trial chamber notes that the prosecution has outlined various time periods for various crimes with the time periods as a whole spanning 5 years. The trial chamber notes the defence acknowledgement that the full time span of crimes committed is 5 years, as documented in its own chart of the temporal range of counts. In the trial chamber's view, it is clear from the evidence, as supported by the submissions of both parties, that the length of time over which the crimes were committed was 5 years, with a concentration of the crimes having been committed during an 18-month or 2-year period within the 5-year time span. In the trial chamber's view, the length of time over which the crimes continued heightens the gravity of the offence. The defence admits that Mr. Taylor's age, health and family circumstances, quote, constitute the essence of the individual circumstances contemplated in Article 19.2 of the statute, unquote, and that they may be regarded as mitigating factors. Mr. Taylor is 64 years old. The trial chamber is not aware of any serious concerns relating to his health, and no medical evidence has been submitted relating to his health. The trial chamber notes that Mr. Taylor has and will continue to have access to medical attention as needed throughout the period of his sentence. His age and the fact that he is married with children are not, in the trial chamber's view, mitigating factors in this case. Further, his social, professional and family background, which the defence submits shows the likelihood of rehabilitation, is not a mitigating factor in the trial chamber's view. The trial chamber recalls that the Special Court Appeals Chamber, as well as the ICTY Appeals Chamber, has held that the primary objectives in sentencing must be retribution and deterrence. Moreover, in the absence of Mr. Taylor's acceptance of responsibility or remorse for the crimes committed, the trial chamber does not consider the likelihood of rehabilitation to be significant, nor is it demonstrated by his social, professional and family background. In light of these considerations, the trial chamber finds that nothing in Mr. Taylor's personal circumstances justifies any mitigation of his sentence. On the question of time served, on the 7th of March 2003, the indictment against Mr. Taylor was approved by the Special Court under seal, and a warrant for Mr. Taylor's arrest was issued. On the 4th of June 2003, the indictment and warrant of arrest were publicly disclosed and formally unsealed 1 week later. On 11th of August 2003, Mr. Taylor stepped down from the presidency. He went into exile to Nigeria, where he remained until 29th of March 2006, when he was arrested by Nigerian authorities following a request by Liberian President Johnson Sirleaf that he be surrendered to the Special Court pursuant to his warrant of arrest. On the same day, he was handed over to the Liberian authorities, who in turn transferred him to the custody of the Special Court. For security reasons, by order of the President of the Court, in June 2006, Mr. Taylor was transferred from Freetown to the Netherlands to stand trial in The Hague, where he has been on remand since. Mr. Taylor, would you please rise for the sentence of the Court? Mr. Taylor, for the foregoing reasons, the trial chamber unanimously sentences you to a single term of imprisonment of 50 years for all of the counts on which you've been found guilty. Credit shall be given to you for the period commencing from 29th of March 2006, during which you were detained in custody pending this trial. Thank you. You can be seated, Mr. Taylor. We will adjourn.
All rise.